Let the Honorable LOP speak, please.
Mr. Deputy Chairman, sir, we've heard the Honorable Law Minister making a very detailed presentation on the proposed constitution amendment, wherein he seeks to now change the present system where the power of consultation in the Constitution vested in the Chief Justice of India, a power which has been repeatedly interpreted and reinterpreted by the Supreme Court, and introduce the concept of a National Judicial Commission. He was very right when he mentioned that my party, the BJP, the NDA, I myself as an individual have always and consistently been a supporter of the National Judicial Commission. We supported it pre-1993. We have supported it through all these stages. And when we were in government, he's very right that I did introduce the bill. We've been consistent. He's a recent convert. He was fair enough to admit that he wants to change his opinion from what was argued in the 1993 case judgment, which is fair enough. It's quite possible for views to evolve. He today found virtues in Justice Venkatachalaya's committee, which was constituted to review the functioning of India's constitution. This was set up in the year 2000. It had many eminent people. Chief Justice Venkatachalaya headed it. People from across the board, different views, opinions. And they came out with a report which had a very high level of scholarship and wisdom behind it. One of the members of the committee is a distinguished nominated member of this Honorable House. Even about the commission, I must say the Honorable Law Minister has now changed his opinion. Because when we set up the Justice Venkatachalaya committee, we were told that you are trying to erase the memory of Dr. Ambedkar. And therefore, the party to which he belongs decided to boycott the functioning of that committee. Today, the Law Minister, I'm glad that history vindicates what the NDA government did, has decided to quote extensively and rely upon the wisdom of the Justice Venkatachalaya Committee. While we were consistently in favor of the National Judicial Commission, the Congress party was never. And one of the reasons that the 2003 amendment could not be carried out because the consistent view of the Congress party was that we must go back, and that was the view of the then, your longest serving law minister, that executive primacy has to be restored. And the fact that executive primacy has to be restored was a fact which never found favor with a large number of political parties. I must say, to the credit of the left parties, that the left parties were also, like the NDA, in favor of a National Judicial Commission. We could have differences with regard to its functioning or the composition, but our commitment was always very clear. So I will come a little later to the objection my distinguished colleague Mr. Ravi Shankar Prasad has raised. But have no doubt about this, our commitment to the National Judicial Commission and to restore the constitutional balance has historically been consistent. And therefore, whenever this bill comes now or next session, standing committee or otherwise, our views are not likely to be altered. And therefore, we need not be told the virtues of what the National Judicial Commission will do, particularly by those who consistently oppose the National Judicial Commission and the very idea of a commission when it was propagated by Justice Venkatachalaya's committee. So while we are discussing this very monumental piece of legislation, because we are going to rework and rewrite a provision in the Constitution, that's the proposal, I think we owe it to both the country and history to explain why we are doing it. The Honorable Law Minister has made a very detailed and a very competent presentation. I just wish to add a few observations to this. What is it which is our principal object? Our principal object is threefold. First, that India must have a completely independent and fearless judiciary. Under no circumstances is this country going to compromise with the basic tenets of independence of judiciary. The second, unlike many other constitutional systems in the world, the power of judicial review with our courts, what was vested in them and the way it has evolved, is extremely wide. They can review a large number of executive decisions unless they impose upon themselves a self-discipline of not wanting to review a particular decision. They can even review within the parameters of their limited jurisdiction legislations which we pass. And subject to the basic structure doctrine, they can also review a constitution amendment which we may bring about pursuant to our constituent power. So our power of judicial review is extremely wide. And under no circumstances are we wanting to compromise with that power at all. This second aspect is, however, subject to a limitation which the constitutional framers themselves imposed, that just as independence of judiciary, power of judicial review are extremely important, separation of powers, which the Law Minister rightly mentioned, is also one of the basic tenets of the Constitution. And therefore, each organ of the state, be it the judiciary, the legislature, the executive, will be supreme within the sphere of its own jurisdiction. And therefore, one cannot tell the other how that power is to be exercised. And therefore, when power of judicial review is exercised, it will be subject to the inbuilt discipline and limitation which the separation of powers creates. And separation of powers is also a part of the basic structure of the Constitution. Neither we can alter it, nor can the Supreme Court alter it. Having said this, sir, when we are reviewing the appointment system, we'll have to look back at how our judicial system has functioned. Initial years after independence, formative years, unity, sovereignty, evolution of the constitutional system, which are our priorities, our courts were reasonably kind to the governments of the day. And therefore, the nation was being built at that stage. It's only in the 1960s that some element of assertion started as far as our courts were concerned. The executive government found it extremely difficult to accept that assertion. And therefore, in the early 70s, a highly dangerous, almost poisonous concept of judges with a social philosophy was given birth to, which in simple language was that India wants people in the judiciary, people who are committed to the philosophy of the then government in power. This was extremely dangerous. And if I can refer to as the darkest phase of Indian judiciary, the mid-70s, we almost lost our status as a democracy because this whole concept of a committed judiciary, judges with a social philosophy had gained grounds. Post that short-lived era, we've had various kinds of expansion, and I must say, to the credit of Indian judiciary, they've expanded their own jurisdiction, they've made procedures simpler, they've safeguarded liberty, they've got into areas through activism. At times, we make adversarial comments on that activism. And if I can look back today, in the last 2 to 3 decades, it's activism almost bordering on assertion, bordering on assertiveness, which could really define the way our courts are going ahead. If we go through this era, and if we keep this brief history in mind and look at the appointment procedures. So the initial years, what my learned friend Mr. Sibal refers to as the age of executive primacy, the pre-93 age, I think the first 2.5 decades after independence, the 50s, the 60s, had men of very high scholarship in the court. This was notwithstanding that executive primacy. Allegations or charges or even comments about individuals was almost non-existent. You had men of great scholarship. The Chief Justice of India would recommend the very best. The government of the day would accept that recommendation. And the system worked with a sense of maturity, which could be a matter of pride for any democracy. The problem really started in the early 70s, when as a reaction against some of the judgments of the Supreme Court, particularly the 1973 judgment in the Keshwananda Bharati case, this whole concept of controlling the court was born. Sir, I have not the least hesitation in saying that if in the mid-1970s India did not become a dictatorship and an autocracy, it was the Keshwananda judgment which prevented India from doing so. Otherwise, the government in the day was almost prepared to do that. Even a review of the judgment had been filed in 1975 before the Supreme Court. And the Chief Justice at one stage had agreed to hear the review. The bench was later dissolved. Now, as a reaction against that judgment, in 1973, this whole concept of controlling the court, and this concept was born in India for the first time. It's after that that the problem really has arisen. In 1982, the law minister gave a very specious reason in a letter to chief ministers and chief justices that 1/3 of judges in every court must come from outside, because if you have outside judges, it will promote national integration. You don't have a chief minister of a state going to another state to rule to promote national integration. The reason given was, let's have judges from outside and therefore it will promote national integration. The court, by a split verdict, 4-3, said the last word belongs to the executive. And therefore, if this country has seen appointments which were lacking in quality, it was post the 1982 judgment. The executive had the last word, and therefore the executive started playing an important role. high courts, particularly across the country, were flooded with such appointments. Why did in 1993, in the Advocates on Record case, did the Supreme Court decide to say that consultation of the Chief Justice of India will actually mean a binding consultation on the government? You can send it back once. Because they said that the word consultation has to be interpreted in the constitutional context. And the constitutional context is that independence of judiciary has to be maintained. And the judges know the lawyers who appear before them. They know the quality of judges in the subordinate courts and in the high courts. And therefore, their assessment is the last word, their assessment is the best. And therefore, in the constitutional context, we'll give the word consultation a meaning which is a little distinct from the meaning the dictionary gives it. And therefore, they made it a binding consultation or a near binding consultation. I do believe, sir, that if this case had been argued in the 50s and the 60s, the word consultation would have got the dictionary meaning. It got a different meaning because the men who were writing the judgment at that time could see in front of them what was happening in the 1980s. And therefore, they decided in order to safeguard the system, an activist approach is required, and too much of executive interference in the matter of appointment of judges can actually play havoc with the whole concept of independence of judiciary, because the seed of the very idea of controlling the court had been born in 1973, if not earlier. But the 1993 judgment, when Mr. Sibal pointed out some of the problems which exist today, the 1993 judgment created another issue. He was concerned with the executive being bypassed almost entirely or substantially. It vested too much power in one individual, and that was the Chief Justice of India. What if the likes, dislikes, assessments, the judgment about individuals of the Chief Justice of India itself was faulty? Could the system could rely too much on the judgment and assessment of one individual? And we saw in that brief phase almost absolute power in the Chief Justice of India, and a fact which was being resented even by his colleagues. And the trigger, therefore, for the 1998 reference was that the Chief Justice could disregard the views of his court, he could disregard the consultation of his senior colleagues, and impose his own whims in terms of appointment to the highest court of the country. And therefore, in a more structured manner, the wider consultation of 1993 became a more structured collegium in 1998. What has it done today? Mr. Sibal fairly pointed out some of the problems, the lack of transparency, the absence of a criteria. Let me point out a few more problems which have arisen. Each judge in the Supreme Court belongs to one parent high court. He has obviously some element of consideration and affection and concern for his parent court. Experience has shown that he becomes the constituency judge of that high court. And therefore, his say in the appointments of that high court becomes very vital. His day-to-day interest becomes very vital. And therefore, all aspirants for being judges in that High Court, whether he is in the collegium or not, have to be on his right side, have to be noticed by him, because they feel that a substantial part of the say in elevation to that High Court will be his. So every High Court will have a constituency judge in the Supreme Court. Sir, I will not go into names because it's not proper or a responsible forum to get into names. The constituency judge has his own likes and dislikes in that High Court. He decides to block the best man from that court from being elevated to the Supreme Court. Until he gives the nod, the best man from that High Court will not come. In recent years, I can count on fingertips some of the most outstanding judges of the High Courts who have not been elevated to the Supreme Court or whose appointments have got delayed to the Supreme Court till the constituency judge retired, because he enjoyed a virtual veto. And therefore, some people of the best judges lost out. They could not come to the Supreme Court till they got the nod from him. And we all know the names, but we can't get into those details. Many factors started influencing. Now, if you see the line of succession as a Chief Justice, of the Chief Justice, the line of succession is always clear. We all know in which year who will be the senior most to be elevated as the Chief Justice. People have started planning their careers, keeping in mind with a third eye on that line of succession. When I am reaching the threshold of eligibility in terms of seniority and stature, so and so is the man who matters. And therefore, you will always find rumors, Mr. Sibal is aware of them, I am aware of them. Who will bring whom is also a subject matter of an assessment. What is happening in the High Courts? So in the High Courts, you have a collegium of 3. Almost each member of the collegium is as important as the other. Members of collegiums will tell you, and they'll tell you more frankly after their retirements, that when the collegiums meet, instead of selecting the very obvious best, obviously some of the obvious best also get selected. It's not like saying that nobody who's good doesn't get selected. Each member of the collegium has his own preferences, and therefore A has to accommodate the preference of B, A and B have to accommodate the preference of C, and they collectively respect the preference of each other. And those eminent lawyers who didn't fall into the preferential list will lose out to those who were a part of that preferred preference. Now, the collegium system, when I compare it to the pre-93 system, I have not the least doubt in saying that we should not even ever think or dream of going back to pre-93. We don't live in a country where quality of politics is also ideal. I'm sure Mr. Sibal must be meeting a large number of people recommended by his party members. And that's a problem every law minister has to follow. Now that you've got a chance, please make sure that your party members are pushed to become judges. If you go back to pre-93, you'll see what happened in the 80s will start happening again. And that's a issue that we have to guard against. We went back to the collegium system, we evolved the collegium system. A collegium is as good as the members of that collegium. Of course, if the members of the collegium are extraordinary members of very high caliber and great objectivity, these aberrations I have pointed out will not take place. But if that is not the case, then you will certainly find the impact of all this taking place. What is the larger impact which has taken place? And I refer to a point which I think my learned friend Mr. Sibbal would agree with, but which probably bypassed his attention, or he didn't want to refer to it as a sitting minister in the government. The creation of this alternative system simultaneously has disturbed one of those three principal objectives that I pointed out: separation of powers. So if we look back at that era and broadly say, when was the court more conventional, when was it conservative, when has it been a very activist court? So judicial activism is welcome. But activism and restraint are two sides of the same coin. An absolute authority in the matter of appointment, an absolute authority in the matter of writing judgments. A single judge of the High Court can be corrected by a division bench. The division bench can be corrected by the Supreme Court. Supreme Court is not infallible, but it is final. Above the Supreme Court, it's only God, and God doesn't correct judgments. He only sits in the final judgment at a much later stage.
Can be punished also.
And therefore we are living in an age where their view is final. And what does finality mean? Look at this age where the transfer of power, where the executive primacy or participation got left out, and how restraint went out of activism. Otherwise, activism coupled with restraint. So if it was activism which helped personal liberty, if it was activism which protected environment, if it was activism which protected the weaker sections of society who couldn't otherwise approach the court, it will be a welcome phenomena. Can in any jurisprudence in the world, under any authority of law, while a terrorist action is on and our soldiers and security forces are sacrificing their life standing in front of the terrorist and fighting them, suddenly emerges a judicial order which says, please provide so many calories of food to the terrorist. The government of the day, the political system, the media, internationally, it happened in Jammu and Kashmir. A terrorist action is on, the security forces are fighting terror, and how many calories must a terrorist get in terms of his food is an obligation imposed by the court. There is no infallible question of, it's obviously an order which raises serious eyebrows, but it's final. The government of the day can't correct it. I've seen a judgment delivered about a year ago, which was a subject matter of great debate, where economic liberalization post 1991, neoliberalism, the dangers of neoliberalism, Now, whether you must have liberalization or not have liberalization can be a subject matter of this House. The Supreme Court of India can't have an economic philosophy. Courts don't formulate policy. Courts have a power of judicial review. Courts can't even review a policy and say, my policy is better than your policy. Courts don't legislate. How special police officers are to function, and how Naxalism is to be fought, how insurgency is to be fought. Now, these are all matters, whether it is security or it is economic policy, whether it is slum clearance. Activism has now gone to an extent that in case after case, when we fail to take action, it's judicial legislation. And it's termed as judicial legislation. We lay down the following guidelines, and those guidelines are effectively the law. Now, it may be putting it too simply if we argue that the political establishment has become weak in this country, parliament is divided, polity is divided, therefore it's happening. But sir, the emergence of this phenomena, normally it is for the court to say that the government of the day must be kept in check. Because the governments may tend to breach the law. The government may tend to upset the political balance. But if there is a danger to the concept of separation of powers being disturbed, no center or state government of any political complexion has ever said, let us try and encroach on the power of the court. The argument given is, governments are not doing their duty, so the court has to step in and do that duty. Sir, with utmost respect, it's a very serious, a very dangerous argument. If government is not doing its duty, please direct them to do their duty. But can't take over the power. If 3 crore cases are pending in court, can anybody turn around and say the courts are not doing their duty because there is a delay, so somebody else will now do that duty? This argument can work the other way around also, and if it did work, we'll be heading for anarchy. Because courts have to decide those cases, we have to probably increase the number of judges. Therefore, this whole argument that we step in and start performing the tasks of a court because governments are not doing their duty. Well, if governments are not doing their duty, compel them, stricture them. Your strictures have great value. Today, we have discussed in so many times, one of the biggest economic challenges we have today. The current account deficit. And when the Honorable Prime Minister was here, I myself pointed out that some of the reasons for the current account deficit could be even domestic. It's not only international. The imbalance in terms of our currency earnings and foreign currency earnings and our spendings. I did point out our excessive imports of coal, because we mismanaged the coal economy. We ourselves in the political system are to be blamed for it. But then I spoke also in terms of iron ore imports. They were a foreign exchange earner.
Export.
I'm sorry, iron exports. How do I criticize the government of the day or state governments? People may have erred. Those who have erred should be arrested, should be prosecuted. Till such time we get a clearance from the court that $10 billion imbalance created by lack of iron ore exports cannot take place.
It is a complete stay. Complete stay.
And each one of these orders whether it was our own mismanagement of the coal economy or the issue of exports, is contributing to the current account deficit, and the current account deficit has taken your dollar rupee parity to where it is today. The level of responsibility, accountability and answerability is of the government. Courts write judgments, they are not answerable. Therefore, if we look at the history of when the power has completely been subsumed, it's only then that this imbalance in the separation of powers has taken place. And I think I don't subscribe to the philosophy which in simple language some people feel we must all get together and correct that imbalance. I think the court must have all the powers which a court has, but the imbalance in the separation of powers needs to be corrected. And therefore, whatever is the restoration of authority, whether legislative or executive, we can't abrogate or abandon our own authority. Because if the imbalance does take place, then systems will find it very difficult to function. There is a difference, sir, between the governments, the legislature, the executive and the court. Our jurisdiction as a legislature is prescribed by the Constitution. The government's powers are defined by the law. If they exceed jurisdiction, it will be struck down. But the court has a power to enlarge its own jurisdiction because their last word on jurisdiction is the final word. You'll find a number of cases. I saw my friend Mr. Naresh Agrawal the other day raising an issue. To what extent must courts monitor investigations? Can monitoring of investigations and trials go on simultaneously? Will it reach to miscarriage of justice? Elsewhere in the world, it probably would have gone into miscarriage of justice. In India, we've learned to live with it. Because the court itself defines its jurisdiction. But in case government stepping out of jurisdiction or the parliament stepping out of jurisdiction, the court has the last word. When court steps out of jurisdiction, they themselves decide whether they have the power or not, and therefore the elasticity of jurisdiction is always there. Sir, just one or two more points. I think one of the big challenges is, and this is a challenge particularly post-91, with economic liberalization, in many principal high courts of the country, legal practice has also become very lucrative. The best are therefore not willing to become judges. I think at some stage the Honorable Law Minister will apply himself to this question. It's an institution which must have the very best. And if the best are not willing to become judges, it creates a serious problem. Two, I think we are going a bit too far now in every legislation in creating post-retirement avenues for judges. There is a proposal you want to increase the age. Please do it, but with a condition. That almost everyone, barring a few notable honorable men who are an exception, wants a job after retirement, and we are lavishly creating it for them. If we don't create it, they themselves create it. I'm glad the Supreme Court has reviewed its verdict saying every member of the CIC must be a judge, retired.
And a bungalow in Delhi.
You have a situation where what should be the fees of a college is an accounting method, is an accounting concept. The Supreme Court by a judicial order said fees of medical colleges and engineering colleges must be fixed by retired judges. and then said in every state we've created 2 more jobs. I think this whole temptation of continuing to occupy a Lithian's bungalow is a very serious temptation. And therefore, kindly review that unless it's absolutely essential, either some of these tribunals must be subsumed into the judicial setup, pay the judges who have retired and retired judges a pension equal to their last drawn pay. Because the danger is greater, the desire of a post-retirement job influences pre-retirement judgments. It's a threat to the independence of judiciary. And once it influences pre-retirement judgments, it adversely impacts on the functioning of our judiciary itself. So just last 2 points, and both are very serious points. I would personally like to see a National Judicial Commission to which has not merely the appointment powers, but to which there is some element of accountability of the judges itself. This whole concept of judicial accountability is unknown and unwritten. Impeachment is a provision which is in the rarest of rare cases almost impossible to arrive at. And when you reach the closure of that procedure, the concerned judge resigns or retires, and therefore impeachment doesn't take place. But misconduct falling short of impeachment is accountable to whom? The judges say judges are accountable. So in India, judges appoint judges, judges are accountable to judges. I think this thinking now requires to be changed. And that's the substance, one of the substances of Mr. Ravi Shankar Prasad's argument. This requires a serious rethink. We don't like the present system, so we are all agreed to change it. We are making a monumental change. Monumental changes are never brought with a knee-jerk reaction. We've always said so, you recently turned to our view and therefore say, we all agree. Now, should the National Judicial Commission only be an appointment body, or should it also have some element of powers in relation to accountability or not? In my respectful submission, it must have powers of accountability. And my last point, and this is why this issue, before I come to one question of procedure, what should be the basis of appointment of a judge? A judge must have an element of scholarship, he must have an experience, he must be objective, he must be a man of integrity, he must have the temperament of a judge, he must have adequate experience, he must have a huge level of maturity. Today in the collegium system, Mr. Sibal complains that we are not told the reasons why a man has been appointed. Please remember the famous saying, when no reasons are given, then no reasons could have been given. Because you pick individuals, that objective assessment of the criteria doesn't take place. So my suggestion to you would be, and it's a matter when the bill gets considered by the standing committee to consider it, how would I want the criteria to be? What is the academic qualification of a candidate? How many years he has put in as a lawyer? Today, in a world with sophisticated internet information technology available, how many cases has he argued? How many cases that he has argued are actually reported judgments? How many articles has he written? How many papers has he presented? How many seminars has he addressed? How many juniors has he trained? What's his level of income? I'm just suggesting a few off the cuff. There could be 20 objective criteria which the collegium will have to consider when the biodata of each individual comes up. Impressionistic assessment is what takes place today. It has to be replaced by an element of objectivity. A threshold limit is required for any job in government. There is no threshold criteria for you to become a judge except the number of years that you have practiced in. And what's your age? Therefore, unless the Commission has strict guidelines that these are the objective criteria on which judges will be appointed, this element of subjectivity in the present system will not be replaced with objectivity. And sir, my final point, why do we feel that this bill must, both the Constitution Amendment and this bill must go to the Standing Committee? Mr. Prasad has said that it's a monumental piece of legislation. I assure you on behalf of my party that whether it comes up on the first day of the next session or otherwise, we are in support of this very concept. I'm sure the Standing Committee will get an opportunity to hear various stakeholders, judges, chief justices of former chief justices, lawyers, bar associations, bar councils. Let everybody give their viewpoint. Let litigants give their viewpoint. Give your report, take it up on the first day of the next session, and take up both simultaneously. And the reason you must take up both simultaneously, because if we pass the Constitution Amendment and replace the Chief Justice's consultation with that of the Commission, we have frozen the power of the Chief Justice, subject to assent of half the assemblies. In this era of present politics we are going through, assuming an election intervenes and the Commission is not created, what will be the situation? You may be sure of the stability of your government, we are not. Assuming your bill gets delayed for some reason and it's not done in 1 month or 2 months, you have taken the power away from the Supreme Court by way of Constitution Amendment. You have not created an alternative system. Constitutional hiatus should never be created by the legislature. And therefore, please ask the Standing Committee, it is chaired by an eminent congressman, to give a recommendation within 4 or 6 weeks. We are in September, the next session is in November. Take it up on the very first day and pass the two together. But the very nature of these two bills is so interlinked and interconnected. Whether power of accountability is to be given to the Commission or not, or power of only appointments is to be given, is an issue which is required to be taken up by the Standing Committee after hearing people, and therefore both these matters are so intrinsically linked, they must come together. My party today and on any later day will support both these bills, subject to whatever minor variations are suggested by the Standing Committee. But please, this requires consultation. This doesn't require a knee-jerk reaction, which we are adopting today. Thank you.
Thank you. Let us have 1 hour lunch break. Yes, House adjourned for 1 hour.